welcome to Crime in Court. This is the state's case, part 50 of California versus Erik and Lyle Menendez. This is their second trial. First trial ended in a mistrial in 93. This is now 1996, where they were convicted with life without the possibility of parole. We are on the second to the last case, or last part, I should say, the second to the last part of the state's case. So this is also the second to the last time that we will hear from Dr. McCarthy on the stand with right now I believe we're on redirect, but we're going to start with a couple of arguments with the attorneys with the jury outside of the room. We left off on so this is November 17th. They left for, I believe it was their lunch break, afternoon breaks. Yeah, so they left at noon. The proceedings were adjourned at 1:30 and they come back for arguments. So that is where we left off from last time. And then we will be getting into the defense's case, which I think is a lot more interesting than this, the ballistics and the mechanical engineering that this guy is testifying to. So let us get started. Please hit the like button and let's begin. Why is my screen all crooked? There you go. All right, so the court says the defendants are in court with counsel with the exception of Mr. Levin and Mr. Khan. So Mr. Khan for the state, Mr. Levin for Erik are not in the room. Ms. Nahira says, yes, Your Honor, I asked that the court be reconvened at this time to deal with two issues which we had just discussed previously and I thought had been resolved, but apparently had not. The two issues deal with discovery of the reports on Mr. Morton and Dr. McCarthy. With regards first to Mr. Morton, because I think that's an easier issue to resolve, counsel stated about a half hour ago, and I have a copy of the report. When I asked about getting a report from Mr. Morton, she stated that he probably wouldn't hit the stand until the 30th. The court still stated they wanted to know when they could get a record from you. She said, I will have a report for them with respect to Mr. Morton on the 20th. Mr. Morton must be a defense witness. The court asks, well, can you get it before Thanksgiving? And Mrs. Abramson replied, I don't know. I haven't talked to him in several days because I have been busy with all the doctors. The implication being that she needed to talk to him to have a report generated. On reviewing the report of Dr. Wecht, MD, that is dated November 13th, 1995, I reviewed when we went back upstairs what it was that he had relied upon to formulate his conclusions. Under number 7, the things that he relied on were first, the report, copies of the reports from Mr. C. Morton, Mr. Dr. M. Fackler, Dr. R. McCarthy, and Dr. R. Lawrence. This leads me to believe that counsel wasn't being completely candid with the court when stating they couldn't have the report as early as Monday, right after Dr. McCarthy testified, because clearly there is a report in existence and they have already turned this over to Dr. Wecht. The second issue that causes me some concern as well, Your Honor, is that with regards to the report of Dr. Fackler, I asked counsel to give me a report, and I believe the court ordered that she provide to the people an unredacted report. Counsel informed me that she did not have a report and that she did not need to have a report and still be able to call this individual to the stand. Her words. She stated that she had a letter from Dr. Martin Fackler that she would turn over to us, but first she wanted to redact it. Apparently, these were severe redactions since they have been redacting this letter for about 20 minutes. We have some concerns once again that it appears from the record that the assertions weren't completely candid or I didn't completely understand what was being asserted earlier. I feel the only appropriate way to resolve this is for the court to see it, both the redacted and unredacted, and determine what should be disclosed to the people. I also have concerns about this report of Dr. Morton that she implied to the court doesn't exist and very clearly does. The court says, okay, let's hear first about Mr. Morton and his report. Ms. Abramson says, what I have from both Mr. Morton and Dr. Fackler were notes that I asked them to write to me so that I could prepare to cross-examine Mr. McCarthy, both before and after the 801 hearing, and what was prepared were notes that they wrote to me. Now, with respect to Mr. Morton, since he's not going to testify for a while, I was going to give what the court should also understand, and I'm sure is obvious to the court. This is a very complicated crime scene and a very complicated set of medical findings. And what we have is a consortium of 5 people who are constantly talking and reviewing and revising opinions about the crime scene. So, I was going to ask Mr. Morton to prepare a final report because he's still doing test firings. He's still doing experimentation. He's still talking to the other witnesses, and since he wasn't scheduled to testify this week, I haven't yet asked him to prepare a final report. What I sent to Dr. Wecht were the notes that Mr. Morton had sent to me. These are internal defense notes. They're not discoverable just because I sent them to Dr. Wecht, but he has them, so when he testifies, if the people want to see them, he has them. But I was going to have Mr. Morton prepare a final report. Now, with respect to Dr. Fackler, when we were first talking about a report from Dr. McCarthy and a report from Dr. Wecht, I didn't realize how full of strategy, tactics, and commentary the notes that I received from Dr. Fackler were. Moreover, those notes were written right after the 801 hearing and have been subject to further revision, at least in Dr. Fackler's thinking, based on my last conversations with him. So, what I have done is I have taken those notes, which are addressed in a letter to me, and the first part of them are entitled, quote, Memo Comments on Transcript, and the second part is entitled, quote, Summary encompassing his report, interview, and testimony, meaning Dr. McCarthy. This is commentary on Dr. McCarthy, and in that commentary is contained Dr. Fackler's conclusions, as I understand them to be at this time, on the wounds that he's commenting on. And so all I did was I took that letter, I cut out, and I have it for the court to see things that I am either not going to ask him to testify about because we've already established it, or I have other witnesses who are going to establish it. I have cut out his commentary to me, and I removed reference to one finding that I know he has since changed, and that is not in controversy. So that's all I've done. The people are extremely impatient. They wanted the report in 5 minutes. We told them it would take 15 minutes, and then it was 20. Ms. Nahara said, We're going to court. The judge isn't going to let him testify. So here we are. Good afternoon. I have the material to show the court. The court says, and Dr. Wecht is going to be testifying when? Ms. Abramson says, the court said we did not have to turn over impeachment evidence before Dr. McCarthy finished testifying, and the notes in the form that these notes were written, they were written as impeachment notes, if you will. I have to talk to Dr. Wecht. I have a conference call with Dr. Wecht and 2 other pathologists tonight at 6 to find out if he feels comfortable coming in next week without a guarantee that he'll be finished. If he does not, I'm going to cancel him and put him over to next week if he's available. Could you not talk while I'm talking? Thank you. The court says, well, Wecht is going to definitely be a witness. Ms. Amerson says he is definitely going to be a witness. He has been the last one to get materials, and that's been the problem. Dr. Fackler had the only set of x-rays, and he was in Toronto last week. The court says, I just wanted to find out if Wecht is going to be a witness and if he has already considered and relied upon the notes that you gave him of Fackler and Morton. Then those materials are going to be turned over to the prosecution anyway. Ms. Amerson says, well, maybe, maybe not. The only report they've received so far is the one of uncontroverted, what he indicates is uncontroverted conclusions on his part for the parts that are impeachment, which report I don't have yet. I don't know if he's relying on their notes anyway. They were submitted to him, and I don't know if he's going to be relying on their notes as compared to the consultations he's been having with Dr. Baden and Dr. Wolf or not. That's what I'm supposed to find out tonight. We're having a 3-way conference call. I don't even know his final conclusions on the controversial wounds. I was going to tell him to prepare a report I would have by Sunday, and I would have it to the prosecution first thing Monday morning, but I don't imagine this is Friday. November 17th, so, she said she would get it to them by Monday morning. But I don't imagine him getting on the stand before late Tuesday, early Wednesday if he comes in late in this week. If he tells me tonight he can't run the risk of coming in this week, he isn't going to testify until the following week. I'm going to give the people the findings I have in writing. I cannot ask these experts to write a report in a day. These notes contain his major findings as I now understand them, and I think it's already obvious from what I have done in cross examination with Dr. McCarthy, mentioning Dr. Fackler by name, what some of his opinions are. None of this is going to be a surprise. The court says, that's why I said earlier this afternoon that I didn't see why you couldn't turn over the entirety of his report to the prosecution. Ms. Abramson says, well, I'm not withholding any impeachment. I'm withholding confidential strategic material, which they're not entitled to have. Like his telling me to do this and to do that and the other, which has nothing to do with his medical opinions. I prepared a report that contains his medical opinions as I understand them right now, and I'm prepared to turn it over to them. The court says, and the rest of the report that you redacted only has in its trial strategy, nothing to do with any opinions he has? Ms. Abramson says, no. It has to do with strategy, something to do with ammunition, which is no longer an issue because the witness has testified, and I'm not going to ask Dr. Fackler about it, and it has to do with one preliminary medical opinion that he had that I believe has changed. In fact, he's told me he's changed it. The court says, don't the people have a right to know that he's changed his opinion? Ms. Abramson says, I don't think so, because this is the game they're playing concerning Dr. Golden. This was a preliminary comment to me to prepare me to cross examine Dr. McCarthy. That's all it was. It was not a formal report, and this witness has been working on this case and consulting on this case and reviewing materials on this case. This was now, this was written before he even saw the CDs, for example. Now he has revised things. This is not his final report. I don't think they have a right to his temporary thinking if I'm not going to offer it as an opinion, period. I'm not going to offer this temporary thinking as an opinion. Therefore, the court says, are you going to offer the final opinion on the same subject? Ms. Abramson says, will I offer a final opinion on the same subject? Yes, if it's the same or different. If the man had a different opinion on some earlier occasion and he put it in writing in a report to you, don't you think the opposition has a right to know it? Ms. Abramson says, it's in the notes to me based on a preliminary idea. He's since got the x-rays and has a different opinion. Why should he be impeached about something he thought about and didn't have a final opinion about? That's what a good scientist does, not make up his findings and refuse to change, but absorb information until he has a final opinion. The court says traditionally that's been the subject of opinion. As to whether people's opinions change or not, my concern is if this man has a certain final opinion that is different than an earlier opinion, then the people should have a right to know that. Miss Abramson says, why? It's not an opinion he's offering in court. If he didn't have an opinion with a level of scientific certainty to offer it, why should they impeach him on his thinking? That's a good point. The court says if he has a final opinion that's different than the preliminary opinion, they have a right to do so. Ms. Abramson says, I don't believe that's true. The court says, you have been exploring this witness throughout. I don't want to characterize his opinions or testimony, just in general. The nature of the inquiry has been, did you have the same opinion, different opinions, things of that nature throughout? Ms. Abramson says, but the court interrupts her and says, that's what's been happening through Dr. Golden. Ms. Abramson says, I don't think you're entitled to the thought process of an expert while he's formulating an opinion. When he has a final opinion that he's prepared to give evidence on or to write a formal report about, that's one thing. But the thought process, I don't believe the people are entitled to. I'm not entitled to the thought process during the process of formulating an opinion from their experts either, only the final opinion. The court says, well, you certainly, number one, could ask a witness whether you had the same opinion or a different opinion or on some prior occasion, whether you thought about it in a different light before or the same light, if the opinion was the same or different. It's clearly a proper question. Your witness has gone farther than that and put it in writing and has given it to you. That's how I look at it. Without looking at the report, I don't know what the subject is or anything else that we're talking about. As far as Mr. Morton is concerned, you said these are notes he provided to you. You have yet to speak with him. I indicated that you should attempt to get a report from him by the 22nd. Ms. Abramson said, right. The court says, and that's still the situation. I don't see any need to deal with it earlier than that. But the notes that were given to Dr. Wecht should be available for the court to review. Ms. Abramson says, I don't know that his report will be any different. I just haven't talked to him to see if he has any additions or changes or anything else. The court says once that report is prepared, both the notes of his notes that were given to Wecht should be available to the court as well. Ms. Abramson says, I have them. The court says there's no reason for me to look at them today because Ms. Abramson says, I'll keep them. I'm not going to destroy them. The court says, I didn't say you would. I just want to look at them. As far as the redaction of Fackler's report, any impeaching evidence, as I said, it's already been the subject of extensive cross-examination with Dr. McCarthy. So there's no reason for it to be turned over. Ms. Abramson says, I didn't cut out any impeaching material, Your Honor. The court says, as far as the rest of it, I'll have to look at the unredacted versions as well. So if you want to turn over the unredacted versions, I'll look at the unredacted. Ms. Abramson says, I can give you my copy and you can look at what I've crossed off. The court says, that's fine. Ms. Abramson says, I have it in exactly that order. The court says, okay, fine. The court reads it. He says, okay, I've reviewed it. I agree that there's some things here that can properly be redacted as trial tactics or strategy, but other things are opinions of the witness or proposed witness on issues that will either be asked of him or are the general subject of his testimony. Ms. Abramson says, well, Your Honor, I would like to go in camera with the court about some of the paragraphs. The court says, I could tell you which ones I think can still be redacted. I don't know if you have it. Ms. Abramson says, I have it. The court says the one starting, I don't know if it's 530 or 539, that one can still be redacted. I don't see that as subject matter that's being litigated. Ms. Abramson says, right, that didn't come up. The court says that that's at this stage anyway. Then a paragraph starting at 635, the part that you redacted starting with the last word on the second line, that full sentence can be redacted. Saberson says, I don't think the next sentence is something that is the manner in which that would be testified to, and they do have this very extensive CV. Court says that's the basis of his opinion or part of his opinion, so I think that should remain. The previous sentence is trial tactics and should or could be redacted. The one starting with the pronoun I. Abramson says, I see. Then 669, the next following page. That's just referred to twice. That's the only reason. It's not even in dispute, and I think it's very obvious. The court says whether it's in dispute or not, it might be something that can be brought out. The only portion I think can be removed would be the portion that starts with all, and stops with out. That phrase. Right. With a comma. Then 730. Ms. Abramson says, this was based on, this isn't something I'd bring out now because of the nature of the testimony that we have actually had. That's all that is. I don't think there's anything wrong with it. That's all it is. The court says, I think it's on the same subject matter, and if it's confirmatory or impeaching of other witnesses, I think it's still part of his report. I can't see any justification for redacting it. 733, I don't understand the reason for your redaction. Ms. Abramson says, this is the paragraph that contained a temporary, this is why I'd like to go in camera and explain to the court temporary opinion that he doesn't have a final opinion on yet. When he does, I will let the people know what it is before he takes the stand. The court says, I'll hear you further on that. All right. Court says, I agree with your redaction, the line under the line summary. Ms. Abramson says, yes. Court says the third page, I assume this is the same thing that you're talking about proceeding. Court says, and I agree with your last redaction on the bottom of the final page. Ms. Abramson says, I have to see that again, Judge. Court says, all right. Ms. Abramson says, I have to see it again. Court says, it says you have item number 5, the last line. Ms. Abramson says, yes. Court says, I'd have to hear you on this other. Ms. Abramson says, right. The court says this is clearly an area that's gone into with other witnesses. All right, so let's have the prosecutor step out for a minute and we'll hear you on this one. I've given my ruling on the others. Pages 41,324 through 41,329 were held in camera and sealed by order of the court. So they had a private. It was in session in court, but it was private, and there were no, the public wasn't allowed in, and the prosecutor wasn't there, but it was on record. They just sealed it. All right, so that is the end of their arguments, it seems. We're going to come back, and the following proceedings are going to be held in front of the jury. So the court says, okay, the defendants are in court, all the lawyers are here, the jury is not. The bailiff has informed me that one of the jurors is sick. I don't know how much you've been told about it. Ms. Abramson says, we know the paramedics were called, Your Honor. Yes, it's juror number 8. Ms. Amerson says, yes, we know. The court says, who complained this morning of an earache, I believe, and a sinus type infection and needed a little time in the morning to get over what she was describing as a headache. She took some medication for that, and after lunch, walking back to the court, she became dizzy and couldn't come over here. So the bailiff informed me that they called the paramedics to see her, and apparently the paramedics feel that she needs rest. They're not taking her anymore, or they're not taking her anywhere, but they are stating that she needs rest. She described to the bailiff, Deputy Wolf, that she has had a sinus infection, and I'm unsure now as to which was of the what duration: a sinus infection for 1 week and a viral infection in the lungs for 2 weeks, and that she's been taking an antibiotic this week, and that's basically all I can tell you. So it doesn't appear that she can continue today. As to whether she will be able to participate next week, Monday, I don't know. And she doesn't really know at this point. That's where we stand. Ms. Abramson says, okay, what I might do, Your Honor, is bring out just one of my out of state witnesses and try to avail myself to some local talent next week in the off chance that this juror might cut our week down from 3 days to two. The court says, well, if she does, oh, so it must be Thanksgiving weekend or week. So they only have 3 days the following week. And the court says, well, if she doesn't come in on Monday, I will proceed without her. Miss Amerson says, excuse me? The court says, if she doesn't come in on Monday, I am not going to keep waiting if it doesn't appear that she is going to be if it doesn't appear that she will be available. It doesn't make sense. Miss Amerson says, well, we'll deal with such an eventuality if it comes up, Your Honor. The court says, well, we are talking about right now as to what to do right now. Ms. Amerson says, right now, I think we should recess. The court says, that's your position? What is your position, Mr. Gessler? Mr. Gessler says, I agree, Your Honor. The court says, people? Yes, I agree. All right. What is your witness situation? Ms. Amerson says, sad. The court says, you are unable to come back on Monday, no doubt. The witness, Dr. McCarthy says, I was supposed to be on another matter on Monday, but I haven't started there and I am in the process here. The court says, okay, how long do you think you're going to be on your redirect? Mr. Khan says, so he's back in the room, I only have another 5 minutes. The court says, recross, 10 minutes. And probably 5 for me, says Mr. Gessler. The court says, most unfortunate then that we couldn't finish that part of it. Miss Abrams says, most unfortunate. The court says she has had ailments periodically throughout, so this is nothing that comes as a surprise. She also, as I recall, suffers from asthma. Miss Abramson says, right. The court says we had to take a break with that. So what we will do then is see what her situation is on Monday, but as I said, if she is unavailable on Monday and there is no clear idea of her availability, we can't lose too many days because of her situation. So, since she is not there at the moment, she is over in the juror's lounge. She will be told of her being excused and coming back on Monday, and there might be some need to arrange for transportation for her. And we will get the other jurors out and tell them to come back on Monday as well. The bailiff says, do you want them out now, Judge? The court says yes. The jury enters the courtroom and the following proceedings were held. The court says, okay, jurors are here. Juror number 8 has been taken ill So she won't be available to participate today, and we'll see how her condition is on Monday. We'll have a recess now and wait and see what her situation is on Monday. She is over in the jurors' lounge, and the sheriffs will arrange for her to get home. But we will excuse you then for the balance of today and ask that you return on Monday as well at 8:30. So they only had half a day today. It's important that you not talk about this case with anybody, that you not form any final opinions about it, and not be exposed to anything about the case in any form outside the courtroom. And we will ask that you return on Monday at 8:30. Let me make some inquiry I have done in the past here. Anyone been exposed to anything about the case outside the courtroom since we last spoke? Okay, we have one juror, that's alternate 4. What was that? In what situation? Alternate juror 4 says it was the radio. I heard the court says, okay, don't tell me what you heard. Okay, anyone else? Okay, juror number 1. Anybody else? Okay, we will talk to you two folks, and then we will let you go as soon as we finish talking to you. And we'll see you back here on Monday. Juror number 1, you can stay where you are, and we will talk to you first. Jury exits the courtroom, and the following proceedings were held. Okay, juror number 1, prosecution intends to rest in the Menendez trial. The court says, okay, and you heard that where? Oh, so that's what the juror heard, was that the prosecution intends to rest. Court says, okay, and you heard that where? The TV, I think, says the juror. And the juror says, yeah. The court says, and did you see anything or just hear that? Just heard that. Okay, and no commentary other than those words? No, no, I got to it before then. Okay, and they were just telling you something you pretty much already knew? Or knew anyway. Juror number 1 says, pretty well had it figured out anyway. Court says, will that influence you at all in this case? I don't think so. Thank you. Then if we could get alternate number 5 out here, alternate number 5, juror number 1 exits the courtroom, and alternate juror number 4 enters the courtroom. He misspoke when he said 5. The court says, hi. Alternate juror number 4 says, I'm alternate 4, Your Honor. Court says, I'm sorry, we have the numbers all mixed up. I do anyway because we excused one person. Yes. Alternate juror number 4 says, I just heard them mention Roger's name on the radio, and at that point, I just turned the radio off, is all. Court says, okay. You refer to him as Roger? Alternate juror number 4 says, I'm sorry, I'm not even sure I know his name, Dr. McCarthy. The court says, and so what did you hear? Alternate juror says, I just heard them say something about his name, so I assumed it was going to be something about the case. So at that point, I immediately turned off the radio. So you just heard the name and nothing else? Alternate juror says, that was it. The court says, first and last name? Well, actually, they said his full name, so whatever his full name is, Dr. X McCarthy, Roger, I think it is. The court says, will that influence you at all in this case? Alternate says, no, it will not. The court says, thanks. I mean, there really was no context to anything there. Court says, were you the one who has plans, an airfare situation? Did the bailiff talk to you at all about that as to whether you could change it? The alternate juror says, I tried to confirm that during lunch, and there is no way I can change the flights. There was no flights available. There was a first class at the time I made the reservation, but that is no longer available. Court says, this is a family situation where you are going? Juror says, yes. My sister-in-law had just had a brand new baby, and we would like to go up and see her, Your Honor. So we made the flight as late as we could for that day. Court says, and that's this coming Wednesday at 3:30. Remember, this is going into a 5-day weekend for Thanksgiving, so leaving early on that day, Ms. Abrahamson didn't want to do that because we're starting the case, they were starting the defense's case, and she has witnesses that she's lined out, and planned for certain times. The alternate juror says, there might have been a flight on Thanksgiving Day, but I didn't want to put her family through that if that's okay with the court. Court says, okay, 3:30 on Wednesday. Thank you. So he did nothing to really. I mean, they did. They tried to get her to change it, but she didn't. All right, or they didn't. The court says, okay, all right, we'll wait for the jurors to leave. There's a brief pause. The court says, okay, the jurors have left. You can leave the witness stand if you like. The witness says, thank you, sir. Court says, I can give you now whatever scheduling I know for other jurors who have made requests. I don't know if I have done this. I was waiting to see if I would get anything more from other jurors. I will give you a jury list also on Monday. Ms. Abramson says, may I have a moment, Your Honor? Court says, sure. And for the record, Dr. McCarthy, you're ordered to return Monday at 8:30. The witness says, yes, sir. Court says, let's see, November the 2nd, as we heard, we had a juror who has flight reservations and has to leave here at 3:15. That's this coming Wednesday. December the 1st, that's the date that Ms. Abramson wanted to leave at 2:30. Ms. Abramson says, no, no, I needed to be done at noon. The court says, noon? I thought you said 2:30. I wrote down 2:30. We also have a juror who has to leave at 3:30 on that day. Ms. Abramson says, I have a 1:05 flight to Portland that day. Court says, okay. And December the 7th, we have a juror who has to leave at the juror also an appointment at 3:30, and the appointment is in Woodland Hills, so I guess no later than 2:45 or so. Ms. Towery says that's December the 7th. Yes, Pearl Harbor Day, says Ms. Abramson. The court says then on December the 19th, we have a juror who has to leave at 1:30. However, that's juror number 8, so depending on her status, we will know more as to whether or not that stands. That must be the sick one. That's December the 19th. She has to leave at 1:30 for a medical appointment involving her child who is going to have surgery. Then we have on December the 22nd, again, juror number 8 who has to be gone at noon. Why is juror 8 still on the jury if she's got all these scheduling issues? That's the day her son's surgery is currently scheduled. Ms. Tari says, I have that as a full day, Your Honor, for some reason for juror surgery. It's just a half day? The court says, that's what I have. Ms. Tari says, I thought you said earlier. The court says, where did you get that information? Ms. Tari says, I got it from you, but I probably wrote it down wrong. Mr. Gessler says, I recall the same. The court says, let me get the note here. Then another juror has to leave, assuming 1311 is still on the jury by then. Another juror has to leave on December 22nd at 12:30. Ms. Abramson says, so either way, it's a half day. The court says she has surgery also. The juror has surgery rescheduled that day. Well, maybe you're right. I'm sorry. 1311, that's the juror's actual like number. But then they get a seat number. I don't know how they do it, but whatever. So I'm sorry. 1311 needs December 22nd off because of surgery rescheduled. Okay. I guess I did give you that. And I just wrote it down wrong. So she has the whole day off, and another juror needs half a day. Miss Aronson says, so that sounds reasonable that we will be off that day. Court says, well, at least half the day. There is another juror who has, I assume, outpatient surgery scheduled that day as well for the afternoon, and that is all I know right now. With everybody getting everybody getting surgery while they're on the jury here. Ms. Abramson says, Judge, do you think we'll still be in trial the day or the week of January 22nd? The court says, you tell me. I don't know. How do I know? Ms. Abramson says, I don't know either. The court says, I'm not the one calling the witnesses. Ms. Abramson says, I will write out to the court that I need to be out of town one day that week. I mean, if we're done. I would be out of town the whole week, but if we're still in session, I need to be out of town one day that week, and hopefully it won't be the week of my final argument, or it will be very tricky, but I'll put it in a letter. The court says, what you can do is, since the people are about to rest, is the defense can give me a revised witness list and order of call here as to what you've told me so far, what you intend, and I guess you're going to modify it a little bit because of the uncertainty of next week. Ms. Abramson says, I'm going to try to do that so I don't have out of town witnesses, two out of town witnesses. Court says, but still give me an idea of who you intend to call after that, those witnesses, and the order in which you intend to call them, and then maybe I could give you a little better idea as to the length of the trial, as well as prosecution and rebuttal when you can give me your calling. Who you're calling, sorry. Ms. Abramson says, well, I can give you some, my end of it. The following people are due to be witnesses over the next couple of weeks: Dr. Fackler, Dr. Wecht, Dr. Van Horn, Mr. Linhart, Mr. Catalani. Those are all from the Sheriff's Department. We also intend to call Miss Lord, and I think we should call. Who is Miss Lord? Says the court. Samerson says Virginia Lord is one of the neighbors who heard pow, 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 and that's a very brief witness. There is another neighbor witness. I have just been reviewing their testimony, Mr. Zlatow, Zlatow, okay, I don't know how to say that, who also heard pow, 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 and we may call him, but these are very brief witnesses. Then we intend to call Mr. Anderson and Ms. Gaskill from the boat and Marticano, and then right now it's our plan to call Erik Menendez. Court says, okay, pretty much this is the order you're talking about. Yeah, I think it's dictated by the court's previous ruling. So the court says, okay, is there going to be any fill-in from the other defendant during this time, or is it to be joined? Mr. Gessler says, this is mostly joint witnesses, Your Honor. Towery says, right. Miss Abramson says, joint witnesses until we call Erik Menendez, and that's when, and then after we call him and call Dr. Wilson, it will be mainly Erik Menendez's defense witnesses, but there may be some spillover depending on the availability of out of state people. Court says, okay. Ms. Abramson says, and I suppose depending on how the defendant and Dr. Wilson are examined, we will have a better idea of how many witnesses we are actually calling in our case in chief, but I think the court has an idea of who the source witnesses are that the court's allowing us to call in our case in chief. Court says, what about Lyle Menendez? Ms. Abramson says he's going to go after we put on all the witnesses. I think we have more witnesses than they do. Court says, so you intend to go after, right? Mr. Gessler says, yeah, we will be after. Court says, any idea of who your witnesses will be at this point? Mr. Gessler says, not at this point, Your Honor, until we see what's happened to that point. Court says, okay, and any rebuttal witnesses at that point that the people know you're going to call or have good reason to believe that you're going to call based upon, I am not asking you to disclose things. Mr. Khan says, we are going to ask that the court order that Erik Menendez be examined by Park Dietz so that he can testify in regard to that. Court says, but other than that, Mr. Khan says, no, that's the only one we're planning for sure at this time. Ms. Nahara says, excuse me, Your Honor? The court says, yes. Ms. Nahara says, at the beginning of the people's case, the court ordered that the people give the defense and the court a complete list, as most accurate and complete as we could make it, of every week and what witnesses would be called for that week. Court says, right. And she didn't adhere to that at all. She changed it like daily. Ms. Nahara says, we would like to request that the court have the defense provide us with that by Monday as well. The court says, well, this is just a. Ms. Abramson says, we're working on it. The court says, an oral presentation. I expect that the defense will do that they are going to provide the court with a list of witnesses and the time estimates that you are realistically expecting as best you can. Ms. Nahara says, Your Honor, for my only concern is they did that, but what they did is basically give a long list, alphabetized with numbers next to them, of 30 minutes, an hour and a half. What we want is a list comparable to what we gave the defense. The court says, now that we're getting close to the scheduling of defense witnesses, I would expect that they put it in a time frame as far as the order in which you expect to call them. Ms. Abramson says, once we get past the impediment has been getting past all these physical evidence experts. Ms. Towery says, we're working on a list that has an order, but again, we certainly can't give weeks or dates until the people's case is over. Exactly, like they're still making decisions. But hopefully, we'll be able to give them something, at least a rough idea of what witnesses and what order next week. The court says, okay, and as I hear you, or I don't hear, I assume you haven't made up your mind as to whether your client is going to testify. Ms. Gessler says, not yet. And as we know, Lyle does not testify in this trial. He testified at length in the first trial. He testified first, in fact, but because of the things he did in the jail, trying to coerce some of his friends, his girlfriend, to perhaps lie on his behalf, They decided not to put him on the stand because the risk was just too great, which, that's their decision. And they had to make it with the best information that they had at the time. Anyways, the court says, okay, yeah, so the client is not going to testify. Lyle's not going to testify. Ms. Nahara says, Your Honor, another problem that raises an issue now is we expect we will be through with Dr. McCarthy on Monday. Counsel tells me that they want to call Dr. Fackler on Monday. If they don't give us the report of Dr. Fackler until Monday, we can't effectively cross-examine him on Monday. The court says, yes, this was a situation where you were going to give them a redacted report or one that dealt with things that weren't impeaching. And Ms. Abramson says, no, that was Dr. Wecht, and they already have that. Dr. Fackler's report is all impeaching. Court says, but now you've done your cross, so really you should give it to them so we don't have a problem of delay of Monday. Ms. Abramson says, would you watch something, Judge, for a moment? Carol, did I tell you before that I would give you the report today? Ms. Nahara said, that's Carol. Ms. Nahara says, the problem with that, Your Honor, is they wanted to give it to us with the caveat that we couldn't discuss it with our experts. Obviously, we need to discuss it with our experts to be prepared to examine Dr. Fackler. The court says the problem is they can always call Dr. McCarthy back anyway, so the record is clear you have turned it over to them. Ms. Abramson says, I told them I would give it to them today. I trust them with that. Ms. Nahara says, well, the problem is we couldn't discuss it with our experts and Dr. McCarthy. Ms. Abramson says, no, just Dr. McCarthy. I don't care who else you want to discuss it with. Ms. Nahara says, I assume we're getting it with no provisions. Um, provisos? I don't know. Provisos? Provisos. Well, Dr. McCarthy is almost through, and whatever is in that report that is impeaching that he hasn't already been asked would certainly be disclosable on recross by the defense if the people went into something like that. So I don't see any reason to restrict the prosecution from talking to him about it. Anything else that we can accomplish here this afternoon dealing with anything? Ms. Abramson says, we could accomplish a lot, Your Honor, if we could leave. The court says, no, that's not what I had in mind. How are we doing with that transcript? Ms. Towery says, I have completed my review of all 3 versions. I haven't had a chance to talk to my lead counsel or my lead co-counsel about it, so I think they need to look at it. I think it's something that we also need to discuss with the prosecutors and perhaps listen to the disputed portions because, as it turns out, there are not too many important parts that are in dispute with respect to the defense version of the transcript at the last trial and the prosecution's new version. So I think we might be able to work it out just by listening to the tape, Your Honor. I know that the court wants to deal with it. Court says that would be perfect. Ms. Towery says, if we do it now, the court is going to end up listening to the tape, and that doesn't seem useful. The court says, that's great if you can work it out. Ms. Nahara says, something else, Your Honor. Court says, yes. Ms. Nahara says, we have Dr. Fackler out of the way, but Dr. Wecht, counsel now tells me that they don't have a report done yet, and I need to know a date the court can give them to get the report done so that they can give it to us. And also, I asked Dr. Gessler, or Mr. Gessler, about Dr. Buckland, and he told me late this week, and I still haven't gotten that report. And Dr. Morton. So these are all like new names that we didn't see in the first trial. So there's a bunch of new experts that we can expect for the defense, by the way, just from listening to this argument. Ms. Abramson says, Mr. Morton is not a doctor. Ms. Nahara says, okay, well, we still need Mr. Morton's. Ms. Abramson says, Mr. Morton is not going to be testifying until after Thanksgiving, and the way I'm going to reschedule, Dr. Wecht is not going to testify until after that either. So I should have a report from Dr. Wecht Monday or Tuesday, and I will turn it over. They will have at least a week to look it over before he testifies, and they will have at least as much time for Mr. Morton because I am going to put Deputy Van Horn, Catalini, and Linhart on before Morton anyways. Ms. Nahara says, I just need a certain date when I can expect these things. Ms. Abramson says, as soon as I have them. Like, okay, I just told you next week. Ms. Nahara says, well, as soon as the court says, well, decide then. Ms. Amerson says, well, I should have a report from Dr. Wecht. I was going to ask him tonight because I thought he was coming Monday to give me one tomorrow or Sunday, and I was going to get it to the prosecution then. I will try to have a report for the prosecution no later than Tuesday on Dr. Wecht, and I will have a report from them with respect to Mr. Morton on the 27th. Court says, and when is Morton going to testify? Ms. Amerson says, probably not until the 30th. Court says, okay, well, you can get it before Thanksgiving. Ms. Amerson says, I don't know. I haven't talked to him in several days because I have been busy with all the doctors, so I can call them. The court says, why don't you call him and see if you can get it get it by the 22nd, so they will have the weekend if they want to use it for that purpose. Ms. Nahara says, and finally, Dr. Buckland. Mr. Gessler says, well, Your Honor, as I told Ms. Nahara this week, Dr. Buckland has severe personal problems going back to Florida, and at this point, I doubted that I would call him, and that if I did call him, I would give her a report at least a week before he testifies. Court says, okay, and as I understood, he has very limited testimony to offer. Mr. Gessler says, very limited testimony to offer, but the problem is because of the nature of his personal problems back in Florida, he might not be available to use as a witness. Court says, okay. From the cross-examination, it sounded like he was going to testify. He was going to testify as to post-mortem or ante-mortem or entrance wounds or exit wounds, something like that. Mr. Gessler says, right. Court says, okay, as far as the exhibits here, can we do anything or benefit from this time to go over exhibits that haven't been received yet, since we're almost through Dr. McCarthy's testimony? Ms. Amerson says, see, that's a problem. We have a series of motions having to do with Mr. McCarthy or Dr. McCarthy, but we sort of need to wait until the people are done. The court says, do those motions relate to the received exhibits? Mr. Gessler says, part of them. Court says, well, if you feel it wouldn't be fruitful to do it now, then we won't. I don't want to get into a situation of excusing the jury for a long time to discuss exhibits. Mr. Gessler says, I don't either, and yet I am afraid that if we go into it before he's completed all of his redirect and recross, that it could be a futile exercise that we'll have to repeat parts of it anyway. I don't believe it will take a long time. There will be objections to exhibits and to testimony. There also will be an 1118.1 as to the lying in wait issue on the special circumstance. I think the court is familiar with the arguments made at the last trial, and I will basically reincorporate them. So I don't. Ms. Towery says, what about Wednesday at 3:15 if we're through? Mr. Gessler says, we can't do it Wednesday at 3:15 if the people rest Monday morning. Ms. Amerson says, yes, we can. Court says, we can always defer the exhibits. Ms. Amerson says, I don't want to interfere with my experts. Mr. Gessler says, I am willing to defer it. That's no problem. Court says we can do two things: defer the hearing, but also ask that you meet and confer in the interim during that time frame to discuss the exhibits that aren't going to be in dispute as you did the last time. Mr. Gessler says, yes, we can do that. Ms. Nahara says, that's good. Court says, anything else we can do here at this point? Ms. Nahara says, that's it. Court says, okay, we will be in recess until Monday. So that was apparently Dr. Roger McCarthy was not on the stand, and all we had was argument because our whatchamacallit was out sick. So you know what? I'm gonna read just a little bit. We'll start off Monday, November 20th, 1995. This is the next day in session after the weekend. The court says, in the trial, the defendants are in court with their lawyers. The people are here. Good morning, ladies and gentlemen. We're ready to resume. We have the jury here. The witness is here. Let's get the jury out, please. The jury entered the courtroom and the following proceedings were held. The court says the jury is in the courtroom. Good morning, ladies and gentlemen. We're ready to resume with testimony. The witness is still on the stand and Would you state your name? He does. The court says, you're reminded you're still under oath. Cross-examination continues, blah, blah, blah. Okay. Or sorry, redirect. This is redirect examination. Dr. Khan is questioning for the state. Dr. McCarthy, I'd like to direct your attention now to the shot that you have numbered shot 10A, and this is an exhibit which has been marked 268 at this proceeding. Now, in forming your opinion in regard to this particular shot, did you rely upon the opinion of Dr. Golden concerning the entry and exit wound for this particular shot? I'm relying on his current opinion. Okay, is that current opinion reflected in the 1995 amendment? Yes. And does his current opinion in the 1995 amendment reflect that the shot is, as you indicated there in your illustration, a shot which entered the lower leg of the body of Kitty Menendez and passes through coming out of the upper leg of Kitty Menendez? Yes. Now, was that his opinion back in 1989 as reflected in the original autopsy report? No. Ms. Abramson says, object, Your Honor, calls for speculation as to whether that's his opinion or not. The court says, objection sustained, the answer stricken. Perhaps you can rephrase the question. Mr. Khan says, yes. Directing your attention back to the original 1989 autopsy report, can you tell us if the wound was so described in that report? It was not. How was it described back in 1989? Abramson says, Your Honor, I'm going to object as irrelevant and hearsay since he's not relying on it. Court says, overruled. The witness says, in 1989, the wound was described as having its entry at the back of the knee and 2 exit points. Mr. Khan says, and the 2 exit points would be which 2 points? Roughly the same points on the knee I've shown as entry and exit. Those were described as 2 exits with an entry in the back of the leg or knee. So just to clarify then, you're saying that in 1989, Dr. Golden said that the entry to this wound was in the back of the knee here. Yes. And that there was an exit here on the bottom of the leg and an exit here at the top of the leg. Is that correct? Above and below the knee. Okay. And now Dr. Golden is of the opinion that the wound is as you illustrated there on the diagram. Yes. Now, did you confer with Dr. Golden sometime before he wrote the 1995 amendment? Yes. And did you express your opinion to Dr. Golden that this is the way the shot took place? Ms. Abramson says, objection, Your Honor, calls for hearsay. Court says, overruled. The witness says, yes, I did. I explained and showed him in the photographs that why I thought it had this geometry and why I thought the back of the knee was an exit/entry. Okay. Mr. Khan says, and sometime after you had this conversation with Dr. Golden, did he then change his opinion and agree with you in his statement or in his 95 amendment? Objection calls for speculation as to whether courts have sustained as to the form of the question. Mr. Khan says, okay. And do you know how long after you had that conversation with Dr. Golden that he issued the 1995 amendment, which agrees with your interpretation of this shot? Objection, Your Honor. It assumes facts, not an evidence. Court says, as to the last portion of it, agreeing to the witness's characterization of the shot is sustained. Mr. Khan says, can you tell us how long after you had that conversation with Dr. Golden did he write the 1995 amendment? Approximately a week. Okay, 10 days, very close. And did you tell Dr. Golden during that conversation with him that you are not a medical doctor? Yes. Now I'd like to direct your attention to another shot, which is illustrated shot 3A and is depicted in Exhibit 254. And that is the shot which you described as a shot which missed going through the French doors. Do you recall that shot? Yes. Now I'd like to ask you at this time about the 2 damaged windows. Did you note during the course of your evaluation of that particular shot that there were, as depicted in this photograph here, 244 showing the 2 French doors that there are actually broken panes of glass, one of the left-hand side, which is also depicted here in Exhibit 244, and another broken pane of glass in the lower right-hand side, looking from the outside of Exhibit 244, which is also depicted here in photograph 246. That was a very long question. He says yes. And did you conclude after evaluating those shots, that it was the shot that passed through the left-hand door looking from the outside that was the shot that struck the tree, which is depicted in photograph 307? Yes. Now, in concluding that it was that shot that caused the damage to that tree, did you rely upon certain measurements? No, I concluded that without those measurements. And your conclusion at that time was based upon what? Just the geometry of the door and the height of the various bars made in it. In my opinion, the only possible shot that could strike the tree. Okay, now, since that time, did you receive some measurements concerning the distances between those panes of glass and the tree, which is demonstrated and has been marked here as Exhibit 278? Yes, they were measured at my request. Mr. Khan says, I would also like to mark at this time another exhibit as 310, which is a detailed measurement of the French doors. The court says 310. Mr. Khan says, can you tell us what this document is that I'm showing you at this time? Yes, this is a dimensional diagram of the French doors prepared at my direction by Dr. Robert Cadlack of my Los Angeles office. Having obtained the measurements of the French doors some time, and more recently measurements of the distance from the French doors to the tree, have you evaluated whether it was possible for the shot on the right-hand door, once again looking for the exterior on that door, to have caused the shot rather than the shot that went through the left door? I evaluated that previously, but now with the dimensions, uh, I can show precisely why it doesn't work. And have you concluded based upon that evaluation that it was, in fact, the shot to the door that you previously indicated that caused the shot to the tree? Yes. And what do you base that on? Well, it's the height of the door of that first crossbar, and obviously not the geometry of the tree. The last 30 minutes, and I finally brought my laser pointer. If you look at this bar right here, so you're pointing to a photograph that has been marked at 240 as 240 for the exterior French doors. Right, that first crossbar is about 30.5 inches, and this room is constrained by the height of that couch in front of the doors, okay? So we have 28 inches to the top of the couch, and we have 30 inches at the height of the crossbar. Now, anything that gets shot, the weapon is too long to fit between the door and the back of the couch, so we know the weapon has to be shooting over the couch, and even if it conceivably could fit there, the shotgun uh, would be a contact shot at the door. You wouldn't see the same size pattern. Be that as it may, there's no question in my mind that the shot is over the couch. You can't get down in front of the couch. Once we know we're shooting over the couch and the couch is a 28-inch obstacle, then the only way something is going to get downrange and your picture sort of obscures the ground, these shots are reasonably up on the tree. If you shoot below the 30-inch barrier and you can see the shot, I reconstruct the center of that shot at about 26 inches of height. You shoot over a 26-inch couch, you're coming down to, and whatever the distance is. The distance between the back of the couch is 26 or 27, call it 28. It doesn't make any difference to the calculations. What that means is you're dropping 2 and 28. You drop 2 inches every time you drop the 2 inches down, changing that. Does anybody understand what he's talking about? Downrange is 32 feet. Drop all of those, and it's about 14 drops, whatever you calculate it. So if you drop 2 inches in 27, you have 14 of those drops. You've dropped 28 inches. The shot hits the base of the tree if it hits it at all. So it's not the shot. What? Based upon that calculation, Have you concluded that it could not have been that shot that struck the tree, but it was, in fact, the shot as you previously indicated in your diagram? That calculation confirms it. I could see that clearly from the geometry, but that shows why dimensionally it does not work. Mr. Khan says, all right, thank you. I have no further questions, Your Honor. The court says recross examination. Mr. Gessler says, oh, sorry, Ms. Abramson says Mr. Gessler is going to have some brief cross. And we are going to stop there. We will finish his testimony. We'll finish Dr. McCarthy's testimony as well as the state's case in the next episode. So make sure you are subscribed, hit the like button, and I will see you guys in the next one. And we will finish the state's case and then get into the defense as well. So that's going to be, I think, a more interesting case to get into. So thank you guys so much for watching. Let me know what you think. Hit the like button, subscribe, all those good things, and I will see you in the next one. Take care. Bye now.